Okay, everyone, we are back. This is another episode of our data privacy podcast. My name is Marcio Katz. I'm the Chief Operating Officer for Get Global International. We are a data privacy consulting firm with operations in Europe, Brazil, and US. And today we have the pleasure to have as our guest David. How are you, David?
Very good. Thanks for having me, Marcio.
Okay, that's fantastic. Today we're going to talk about Colorado's data privacy law. And most of our listeners, they already know that there are five different states in the US that already have a data privacy regulation. California, Colorado, Utah, Virginia, and Connecticut. And today we're going to talk about Colorado. But before we start talking about the law itself. Let's talk a little bit about you. How do you get involved with data privacy?
I'm the vice chair, one of the vice chairs of Cooley's cyber data privacy group. So I've been a lawyer in this space since about 2002. I first became involved when I set out to combine some of my legal background with technology and found myself working on cyber security related issues and related to cyber insurance, in fact. From there, I staked out on my own for a bit, started a law firm, and eventually started working for bigger firms like Cooley, where I am now.
Okay, very interesting. And you know that in the US, data privacy regulation is, I would say, a little bit confusing because the US, you know, we don't have a more comprehensive data privacy regulations, so it's more sectorial. And now we have those state laws. I want to hear from you. What do you think about the US data privacy regulation? What do you think it should be? Or if you are okay the way things are being addressed here in the US when it comes to data privacy? I would definitely love to hear your opinion about that.
Yeah, I mean, I think you're right. It is confusing and complex. Maybe more so than other jurisdictions. Although there are complex issues in Europe and in Asia Pac and Latin America as well. But I think here the complexity is based on the fact that there's not a unified law that overrides or preempts state law. So there is, of course, a bill that's being considered. Unclear whether it will pass. But not only do we have sectoral laws that govern, financial industries, healthcare industries, but we have a federal overlay as well, and then we have a state law overlay. So when it comes down to it, there are a lot of different laws a lawyer needs to consider when its clients are working on a national level. And most companies that we work with are not cabined in working in one particular state or another state. They do have a national reach. So that makes it much more difficult to understand which laws apply and how to actually deal with them. The other complicating factor is there are a lot of privacy related laws that have been on the books for quite some time that were passed before, even the internet was invented and used on a mass basis. So we have a pretty active class action bar that is actually going out and trying to find companies to go after for privacy violations. And what has been happening there is they've been using these older laws like the Wiretap Act or the Consumer Fraud and Abuse Act to try to go after companies after a data breach or for privacy violations. And these laws don't quite fit because they weren't designed to address the current world we live in. But that just makes it more complex for companies to try to anticipate where some of these older laws may affect them in terms of their processing activities.
Mm-hmm. Mm-hmm. Yeah, interesting. I have one more question. In some other countries, we see data privacy advisors coming from different fields, like information security professionals, compliance, and so on. Most of the data privacy professionals that I have met here in the US are lawyers. Um, I don't know if you agree with that, that most of the data privacy professionals are lawyers. And if you do agree with that, why do you think that so many lawyers are involved in giving legal advice on data privacy and not so many other professionals are seeing data privacy as a field full of opportunities?
Right. I think, well, first, I think there are more consultants and security vendors, privacy vendors that are coming into the play, including IT related vendors. Privacy tech is becoming a much bigger area right now. I mean, I think the reason lawyers in the US are involved is because at the end of the day, the obligations and how you satisfy those obligations come down to a legal interpretation of some sort. Now, you can have people coming in and helping organizations do things like data mapping or setting up a consent process or establishing some sort of methodology for satisfying data subject requests. All of that is more the implementation realm, right, as opposed to the interpretation realm. And so there's probably some gray between those two areas, but at the end of the day, I think, especially because of the active kind of class action bar I mentioned, aggressive regulators increasingly more so, most organizations are looking to their lawyers to help them understand what they need to do when it comes to these privacy laws. The other thing I think is a phenomenon is the fact that, as you mentioned, sort of the confusion and sort of the gray areas and the gaps in the laws, right? And we live in a very complex world. Many companies are doing a lot with data these days, and a lot of complex data processing, artificial intelligence, machine learning, biometric data, genetic information. Data is everywhere, and it is being utilized as a key factor for companies in terms of their business, right? So the stakes are very high when it comes to the ability to understand the data that's being processed and how a company can use it to further their business model at the end of the day, right? So that's another area where lawyers excel, is understanding where those gray areas are and helping companies position themselves to be compliant while achieving the goals that they have from a business perspective. So I think that is a natural spot for privacy lawyers to reside. And maybe less so for implementation related consultants and such. But what I'm really seeing now is consultants, IT companies, lawyers, compliance people. Really, we're all having to work together to figure out these problems. It's not there's not one group that can claim to have the magic solution to every problem. And so we work regularly with the consultants and bring them in for certain types of analysis, and we collaborate with them at the end of the day. That's really what is happening now in the privacy realm. Things are so fast moving, so complex, so kind of different between jurisdictions that no one really kind of owns all the knowledge. And so by working together, that's how we help not only our clients but privacy in general. It enhances, and the compliance framework eventually matures so that hopefully we are getting to a spot where there's an appropriate balance between the business community and really the consumer community.
Interesting. We've seen this the same thing, the same phenomenon in different parts of the world. At the beginning, we gotta speak with the lawyers because it starts with a new law. So someone needs to interpret, needs to tell us what that law is about, what are the obligations, and how to interpret those gray areas that usually rise with a new regulation. But after that, the whole market start to realize that the solution, in order to help you comply with this new legislation, is not just legal advice. You gotta, run an assessment, understand how the company process personal information, try to understand what the gaps are, and then implement a data privacy program, changing process, sometimes training some specific areas of the company. Sometimes it's paperwork, it's a legal advice. We gotta work on the contracts with the vendors. We gotta, draft some disclaimers. Or sometimes we even have to implement a data privacy software just because we are processing personal data in a large scale. So I feel that the market is realizing that there are so many opportunities, not just for lawyers, but for other professionals. And it's the same thing that we've seen in some other parts of the world, that data privacy is something that has been there for a while. Europe, for example. Not so many US companies have a data privacy program in place. Do you think that's something that's gonna get bigger and bigger by the time we have those laws enforceable? How do you see it?
It's a great question. So going to the beginning of your comment, I think, what happens is that collaboration process where the industry, will say, starts to agree on certain types of positions or certain types of interpretations, right? So, at the beginning, it's unclear. Over time, you start to see patterns, you start to see a consolidation, which then it makes it easier to actually address whatever problems or issues or compliance you need to address. And so that evolution, I think, is very interesting because there's a lot of stakeholders providing input. It's regulators, it's lawyers, it's consultants, it's businesses. And you eventually get to something, again, that is more in balance and more in the middle. So that, I think, is an interesting process. Another thing you mentioned, I think, is important to talk about is the question and issue of privacy is not just about complying with the laws, right? There are big societal issues that are involved, but there's also, from the business perspective, a business goal, right? And ultimately, it comes down to a risk assessment, right? Balancing of and understanding of that risk. And so the questions related to privacy compliance in my world is increasingly are becoming business decisions. Not lawyers, not consultants, but CFOs, CEOs, the managers of the organization, who realize that in order to achieve their goals, they really need to deal with privacy issues as a barrier to entering the market in some cases for a lot of companies. And if they don't, even if at the beginning perhaps they're okay, eventually, oftentimes they will find themselves in a position that if they don't address the issues early, either in the design of their product or service or in their business model, they may find themselves in a position where they can't do what they thought they could do with the data that they have, right? And that's a very dangerous spot to be in because you can't easily reverse some of the decisions you make early on strategically when it comes to dealing with personal information and compliance and balancing these things out. So increasingly, we're seeing the conversation around privacy and data security and how to manage it and deal with it flow to the beginning of the decision-making process, the business planning phase, the product development phase, before the marketing team goes out and does a big campaign using data, which flows into your question at the end, which was about privacy programs. And what I'm seeing, and what I think the next kind of big thing will be in terms of what we're doing as professionals is governance, privacy governance. We saw it with information security, the development of formalized written information security programs, not just putting technical controls in place, but documenting those controls, putting policies in place, formalizing risk assessments. That all, from probably early 2000s until today was an evolutionary process, right? And now everyone, most companies that deal with data have, who are serious about it at least, have some sort of written security program. Now we're getting to the place where privacy has the same implications, right? Where if you're working in an organization where the marketing department, I don't want to pick on marketing, but it's often marketing or product development. We'll put them both in the same bucket for now. But when they're working by themselves and taking data and utilizing it or collecting it a certain way or transferring it, and they're not getting any kind of input from the legal team, from the risk team, from their consultants, they may be putting the company at risk. And the risk is increasingly more serious with all the regulations, with all the regulators. But oftentimes, especially for companies that are B2B, the risk is you do something with data that is makes your customers unhappy, then they lose trust and they want to walk away. So without privacy governance, the decisions that are made sometimes are in a vacuum within certain divisions or certain groups in a company could pose serious risk to an organization. So we're seeing and we're developing privacy governance programs that have an escalation path. If you're in the marketing department and you have a new data use that you'd like to explore, you got to escalate up to your privacy officer or your DPO or the legal team, whatever works for the organization. But the point is, someone needs to help to look at that issue. Now, one thing that I think scares people is that, when you start talking to lawyers, you're always worried, oh, if I go and start talking to them, they're just going to say, no, we can't do that, right? So I do think that privacy lawyers and, again, consultants and others have a special role to be enablers, right? To be able to give you a fair opinion as to when something really crosses the line, where it's hitting the red zone, right? Versus other situations where there's some gray and you can interpret things in a reasonable fashion. But ultimately, a privacy lawyer, I think the good ones are those that are looking for solutions, right? And are able to balance the privacy concerns and compliance concerns against the business goals and come to an actionable plan that allows the company to achieve its goals. Now, maybe they have to do things differently, or maybe not all of their goals are achievable, but the majority of what they're looking to do, they're able to do while complying with the law and being privacy protective. If you don't have that privacy governance in place, you don't necessarily get that balance. And that's, I think that's where companies, as they mature, are going to be building these more formalized programs.
Mm-hmm. Interesting. Yeah, definitely privacy is becoming more strategic for any company, because
100%.
if you don't pay, attention to this issue, definitely something might come up, and that you won't have a way to deal with it, because it's something that you should have you should have thought about it before. So
Anticipated.
yeah, anticipated. Yeah, that's the point. You mentioned an interesting thing that sometimes I struggle in making people understand the difference between data privacy and data protection. Sometimes people even, I don't need to worry about it because, the data is protected. Even if the data is protected, that means that your privacy is protected. And I need to explain to them there is a difference between data privacy and data protection. Can you explain to us how you see those things?
Well, I'm assuming when you mean data protection, you're talking more about data security. Is that fair?
Yeah,
Yeah. I mean, this has always been a tension. Information security and privacy, they're different, but they overlap, of course, right? You cannot, the mantra, the cliche is you can't have privacy without data protection or security. And that's a true statement. When you're protecting,
but you can have protection without privacy, right?
Correct. You can. And I would, the way I would explain it to people is data protection is about protecting information from leaking or being obtained by threat actors or third parties. It's about literally, it's more about access than anything else, right? Now, of course, that access can lead to misuse, which can hurt your privacy. Someone can come in, steal data from a company, and then put it on the dark web or put it on a website, and suddenly all your personal information is there for the world to see. That is how a way that data protection failures can result in privacy issues. But in my opinion, the privacy side of the equation is more about data use, right? You're processing and collecting certain data. The question is, how do you want to use the data? How can you use the data? What does the law say about how you can use it? And the use of the data is what sometimes implicates privacy issues for individuals, right? So if you're selling data, perhaps that could be someone could have a problem with that from a privacy perspective. Or if you're using sensitive data to make important decisions about people, their eligibility for insurance or healthcare or a job, then that becomes something that impacts people directly. So when I try to explain the difference between privacy and security, I try to go to that aspect of things. It's not the protection you're concerned about. It's more the use when it comes to privacy, and how that use or that collection could potentially adversely impact an individual.
Interesting. Okay, now talking about the Colorado data privacy law.
Sure.
What do you have to say about this new law? I mean, I know that some other states have passed the same kind of law, but there are some differences between them regarding the Colorado law. How do you see that law, or how can you explain to us how it's going to work?
Yeah, I think Colorado's law, of course, this is the big issue, right? Every law has, of the 5 that we have, and probably we'll have 50 in a year or two, there are slight
Hopefully
variations.
not, but anyway.
That's what we said when California passed its data breach law, and then now we have 50.
And now we have 50. Yeah, right.
But the point is, the differences are there. And actually, that's one of the biggest challenges, if stepping back for a second, is drafting a privacy policy that is still readable and understandable, but then actually addresses all of the various state laws and the differences between them potentially. Even defined terms, sensitive data versus sensitive personal information, they can vary by state, right? And so if you just use a single term, and you may not be actually capturing what is strictly written on a particular in a particular statute. So I'd say Colorado, it's like sort of we have the 80-20 type rule. 80% of it's pretty simpler, maybe 90% of it's pretty similar to other states, and maybe there's some variations in 10% of the law, but nothing too kind of onerous, or nothing that sticks out too much relative to the other laws, I would say at this point. Colorado's law has a data impact assessment type process. I think it's one of the first laws. Now California's CPRA has that, and Virginia has that. So that's something that is new, but other laws have that process now. And of course, that's similar to Europe and what they do in Europe for sensitive data processing. Colorado's law, like most of the other new laws, doesn't apply to employee data. Doesn't apply to business data. So it's mainly individual consumers. I know that in California, the CPRA and CCPA, the exemption for employees and business representative was allowed to expire. So we're having to deal with a lot of new types of information that perhaps before we were not dealing with when it comes to California. But I think the good news from a business point of view is that employee information, business to business information, is outside of scope in Colorado. The thresholds in Colorado are interesting to be applicable. There's no monetary threshold. So in California, you could be a business that processes the personal information of one California resident. If your annual revenue was above 25 million, you need to comply. Colorado, it's based on the number of residents you process. So it's either over 100,000 residents of Colorado whose information you process, or you sell information and process over 25,000 Colorado residents.
So even a startup would have to comply with the regulation if they process personal information, right?
Of over 100,000, or they sell and process over 25,000. So,
okay.
Good point. Your many startups. The word startup is very kind of misleading these days, because a lot of companies who are startups are often funded, and many of them have a lot of data. So they may not have a lot of funding, of course, but they may find themselves subject to these laws once they get over those thresholds.
And once they are on a startup, that means that it's going to be privacy by design, because you are starting. So from the beginning, you should consider privacy right away.
That's such a great point. I mean, Cooley, we're a firm that got our start in technology law. We're expanded way beyond that now, but a lot of our clients are in that phase. And over the years, since I've been here, that has been the interesting phenomenon, is that perhaps in 2018 timeframe, when I started, these startup companies were not really thinking about privacy very much. They were trying to get to market, building out their software as a service or whatever their product was. Privacy was an afterthought. It actually would come up more frequently during like a funding round, right, where the other side is doing some diligence, and suddenly they realize they're getting questions asked about privacy, and they haven't done it.
What about privacy, right?
Exactly. So that started to create, and I also think a lot of our clients, at least, are B2B. So smaller companies working with larger companies, where the larger company, much more mature when it comes to privacy and security, and asking some very difficult questions of the smaller company whose service or software they're looking to purchase. So in 2018, it was an afterthought, but now for our emerging marketing companies and our growth companies, especially, as you just pointed out, we're being brought in at business planning stage, product development stage, strategic marketing stage, sitting alongside of the folks who are designing each of those types of plans or initiatives, and proactively addressing privacy out of the gate. And what the realization I've seen, frankly, is that the smart business people and the people that are dealing with these issues, running their companies, really, they are understanding that if you don't deal with the issue early, you are potentially preventing yourself from going fully to market and putting yourself in a position where you may have to fix things that may be difficult to actually fix later. Yep. And so that realization is become the norm, I would say. And companies now are coming to us very early. And we're getting, from my perspective, that's very fun work to do, right? Because you're sitting with the product development team and the engineers even, and really sitting down and helping them design and enable what they're trying to do. And that is really rewarding work, because, once you get it right, you see it all work. They're able to do what they want to do. They're able to be compliant. They're able to show they're respecting privacy, which is a win-win-win for everyone there.
Yeah, I remember one interview that I gave for a Portuguese newspaper like 15 years ago. They were talking about this company called Google, and it was becoming something big. And there was a video explaining what Google would be in the future. And people started getting scared, because they would have, control over everything. And they asked me if the government should do something, should regulate, the use of information by this company. And I said, yeah, they should have done that before, because now that the baby is born, and it's a big baby already, you're not going to be able to put the baby back to the mother's, value because it's not going to work. And I feel that many companies, they become big, they have like a big infrastructure, employees, but maybe their product is not compliant with these laws, and they will have like big problems trying to change their business model in order to keep making money with these new regulations. And of course, I'm talking about the big tech companies, the big ones. I don't know what they're going to do, but if these regulations start popping up everywhere, they got to do something.
Well, I can't speak to Google specifically, but I
Mm-hmm.
can say every little company wants and thinks they're going to become a big company, right?
Yeah,
So
right.
the same thing holds. And for companies, the big companies that are big now, they of course were small at one point, right? And the companies that we know the names of, all of you could rattle them
The
off.
big ones.
That are being
Mm-hmm.
scrutinized now, in their defense, there were no laws really when they started,
Mm-hmm.
right?
Yeah, they're right.
So
I'm
I
not
mean,
saying that they are wrong. I'm just saying that they got to do something. I mean, they
well,
will have to
now they're
change.
having to react, right? And now they're
Yeah.
having to. Well, they're reacting and they're being proactive. They're doing both, right? Many
Mm-hmm.
are doing both in anticipation of that regulation and have been doing more
Mm-hmm.
privacy forward type of implementations, right? This is before even the state laws were passed, even before GDPR. I would argue this was
Mm-hmm.
on the radar for bigger but more mature companies. But now the change is it's on the radar for the entire.
But I
economy.
do feel that it was something that you could foresee. This would come at certain point. But I mean, they made a lot of money, and as you said, I mean, there was no law, so it's fine. And
Yeah.
I really like everything that they've done for the society already. But for the new ones, they got to think about the data privacy, or it's not going to work because.
Well, I agree. I would add this, one of the key takeaways, and I mentioned it earlier. So when we're going into a client at the stage early on and helping them build privacy and data protection into their offering, we're saying, okay, what does the world look like right now? Right? Okay, that's we can say what the world looks like right now. Then we have to say to them, okay, that's great, but and not only what does the world look like, but what does your product and service look like? Then the question is, what's it going to look like in a year, right? So, and then not only your product service, but what's the environment, the privacy environment going to look like in a year? So again, this is a fun part of the job is we don't just sit there and say, okay, what you're doing today is great. Here's how you comply. But we need to start anticipating what the world's going to be like. I say a year. In our space, it could be 6 months or a week. Sometimes it seems, where things change overnight. And so part of what we have to do is sit down with the client and say, okay, this is your business model today. This is how you want to use personal information. But what happens 6 months from now, a year from now? What do you want to do? Do you want to do something different? Do you want to do something more or less? What's your business model? And then we say to ourselves, okay, what's the privacy environment and compliance environment going to look like? And we're trying to future-proof to some degree what our clients are doing because it happens so quickly, and we're trying to anticipate where the pain points are going to be, where their clients or customers are going to ask questions. How do we get out ahead of this? And that's really the sort of the next evolution, I think, is not just anticipating what you have to do and dealing with it today, but trying to maybe get ahead of where you think things are going to be. And we've seen companies who are doing things that are not required by the law when it comes to handling personal information, right? And they're the ones who are doing that anticipation and saying, you know what, it's better for business in the long run if we do things even that are not required, because it'll help with our relationships with our customers, our consumers, just generally, societally, like some of the things you were saying a second ago. And that type of evolutionary thinking is sort of, I think we're at the beginning of that but I'm seeing it more and more where I talk to a client and they say, we're only going to use data this way. And I say, are you sure you don't want to use it this way? Because in the future, you may want to do
Things are
something different.
changing.
Yeah.
Yeah.
And they say, no, I'd rather just be more limited. We want to make sure we're viewed as being privacy forward. And so even though we could maybe do something differently with data, we're making the deliberate choice to limit how we're going to do things, because it's important not only to our customers, but they view it as important to the business and as furthering the business down the line. So I think that's really encouraging. And that's where I think that's even more than passing laws. That's where you see actual change happening, where people's attitudes change and how they view something changes more fundamentally than just a law telling you to do something.
I totally agree with you. And I think that a good way to anticipate the change that might come is to implement a data privacy program based on the GDPR, just because it's a more comprehensive regulation. So I think that there are some things that you can anticipate, and that once you have that already in place, even if it's not required by the US law, might help you in the future to deal with data privacy. So good practices that you find in the general data protection regulation. What do you think about it?
I don't know if
not 100%.
I don't know if I would use GDPR as a model. I think my actual opinion on GDPR and some of these laws is that they have put compliance before privacy. And what I mean by that is there are a bunch of things that need to be done under these laws. But I'm not sure that they actually increase people's privacy. First of all, no one has shown me a way to measure that, right? So can anyone in this world say that, okay, because GDPR has been in place since 2018, that European privacy is better or that people have more privacy? I don't think that can be proven in any way that I'm aware of.
No, I do feel that certain situations that we were used to face and have to deal with, we don't have to deal with anymore. And I'm telling you that as someone who has lived in Europe for a while.
Like, give me an example of something.
Telemarketing. I mean, you got calls from companies all the time in the US, every single day. The same thing, you would have to face the same thing in Europe 5 years ago.
Yeah.
Now, that has changed.
That's fine, but I mean, I don't consider frankly telemarketing a big privacy issue. It's a nuisance, but I consider privacy about data use and people understanding a lot of information about me. Getting phone calls, annoying. I hear you.
Well, at least they need to know who you are, your telephone, and if
they
you
still
might
know that.
be
They just
interested.
can't call you.
Yeah, I mean, so that's a different issue. I think that what is privacy for me and what's privacy for you, that's a whole different thing. But yeah, I do feel that I'm not a GDPR fan at all. I have helped the Brazilian government drafting the LGPD, and unfortunately, they choose to follow the European standard. And that wasn't my decision. It was a political decision. Once they have decided that, I tried to help to do my best. But I do see some changes after the GDPR. I don't know if they achieved exactly what they were planning to, but definitely there were changes.
It's not just it's the implementation of the law too, from a regulatory point of view. So it's not just the law; it's how the regulators react to it, how they interpret it. And again, my complaint, it's not just GDPR; it's all privacy laws. Is that basically the laws set up a series of things that companies need to do to be able to use data in a certain way. And if you can do those things, then you can use data. And companies with good lawyers and money can usually do those things. I mean, at the end of the day. And so, and I also think some of the interpretations are so kind of draconian. A lot of the cross-border issues that we've seen. Saying that regulators saying cloud computing is illegal, or Google Analytics is illegal, right? And so these types of kind of decisions that are sort of guided by interpretations of the statute, but don't look at the big picture of things. I think that that's how we're getting caught up in the minutia of the requirements and losing the big picture in many ways. And so you have just all these things you need to do. It's expensive, and you could say that perhaps it actually it harms innovators who don't have the resources perhaps to do all the things that need to be done and understand those laws. The more entrenched companies do have those resources. So, when you're focused just on the law and complying with a specific requirement, and you lose sight of whether or not you're achieving the goal of better privacy. And I think part of the problem is no one ever defined what that goal is. The way that legislation comes about, especially in the U.S., my view is there's almost a competition. We want to be seen as doing something about privacy, but whatever you're doing, do you know that you have a way to prove that it worked? And
good point. Yeah, good point. The other reason why I say that it would be a good thing to implement a data privacy program based on the GDPR is foreseeing the future. Usually companies, they want to be big, become a big corporation, as you said, most of them. And definitely the European market is something that you should consider if you want to expand and go internationally. But anyway, coming back to the Colorado law, let me try. Yeah, I think I'm going to tell our staff to change the name of this podcast. It's not about the Colorado law at all. It's a great conversation about data privacy. That's pretty much it. But let me try to help you wrap up the Colorado law. Talking about definitions. So every data privacy regulation defines what personal information or personal data is. Under the Colorado law, what's the definition of personal information or personal data?
Very broad, very simple. Information linked or reasonably linkable to an identifiable individual or identified individual.
Okay. That's a GDPR.
Very similar to GDPR.
Very GDPR definition.
The FTC defined this term a while back, and we still see people work with people or encounter people who say an IP address is not personally identifiable information or personal information. They use the word personally identifiable. We see people that say in like a clinical trial study that key-coded data is not personal information. And usually that's one of the first conversations we have with our client. They say, oh, everything we have is anonymized, de-identified. I say, well, you have device IDs, IP addresses. Like, oh, yeah, but you can't identify the person. I said, well, you can't.
Are you sure you can't? Because when they say anonymization, they anonymize the information, but they still have a way to convert, to get back to the status quo. That means that person is identifiable for that company. And if that person is identifiable, it's still personal information under the Colorado definition, right?
That's interesting. So when it comes to being identifiable, right? The Colorado law has some interesting language about a process in place that where you are trying to prevent it from being re-identified and following that process. And this was as I was looking and refreshing myself today on Colorado's definitions, the question that always comes up is when some data that a company has, it has been, we'll say pseudonymized to start out. Like it's been key coded, let's say. and our client says, well, we can't identify it. Like, it would be very, very difficult for us to do so. So there's this concept of reasonably identifiable, right? The question legally becomes, is it reasonably identifiable to the company that has the data, or is it reasonably identifiable in a bigger sense where someone could go to in, let's say, the clinical trial study. They could get the data from the site that's doing the study and connect the person to the number and therefore identify them. There are two ways to interpret that, right? And the Colorado law, I mean, one could argue that if you have you could be more focused on the individual or the individual company. And if they have certain processes in place that make it difficult for them to be able to re-identify, perhaps it could fall into the definition. Now, I'm not saying that as a position. I'm saying that is one interpretation.
And here is my 2 cents. And my European experience. If that information is identifiable for that company, it's a personal information. If it's not for that company, but it might be for a different company, that changes. So it's anonymized. So it's not the personal information. So let's say that I have a list of telephone numbers. Those people are not identifiable for me because I have no way to connect that number to those people. I don't know those people. But that same list in a telecom company, they would be identifiable in that context. So, and I'm talking about the European experience. It doesn't mean that US is going to interpret it the same way. Okay.
Yeah, I've had other Europeans say that the key coded data is actually only pseudonymized and have a broader view of that, right? And even the telephone numbers, one might argue that if I had a list of telephone numbers, there are probably 100 services now on the internet. It would not take me much effort to go in and find a service, plug a phone number in, and get someone's name, right? But I could also see a situation where, again, going with the clinical trial example, the data is so key coded and so indistinct that it would you'd have to almost have a data breach for a third party to re-identify it. They'd have to go and steal the key from someone else. And this is kind of where data protection comes back into play, right? If the way to resolve the data to an individual is very difficult, and the way that it could happen is protected and secure, I mean, relative to the party holding the data, it is anonymized, and it just in a general sense, practically speaking, right? It would take some serious effort, and that's where this reasonableness standard comes in, right? And again, my experience where European lawyers have interpreted it, anonymization very broadly. That's one place where maybe in the U.S. things could be viewed differently, and maybe they will. And that's going back to the beginning of the conversation. That's the evolution that will happen. Eventually we'll find out what these terms mean.
Yeah, good. We spoke about definition. Let's talk about privacy, the principles. Does the Colorado law bring some principles and some rules regarding privacy, like minimization and things like that?
Yeah. So, and again, we'll give kudos to Europe. A lot of the new laws are more reflective of the European approach. They use even the terms controller, processor, where California, you use business and service provider. So
California even has an agency, a data protection authority.
Yep.
So that's totally GDPR, right?
Yeah, no, GDPR is reflected in everything, but there are definitely differences. But yeah, I mean, so transparency, providing a legal a notice of the data processing activity. Interestingly, though, none of the laws have brought in the concept of establishing a legal basis for processing, which is different from Europe, very different from Europe. I mean, now there are some consent requirements, but there aren't any other legal kind of broad sets of legal bases that are.
And I do like that. I don't like the concept of a legal basis, like a box. Even
I
though
don't
one
know.
of my books that were published is about legitimate interest, and that was my contribution for the Brazilian government, because they didn't want to have these legal base, but once they choose to follow the European standard, that's definitely one of the legal base they should have, mostly because we work with companies and they need to innovate. If they need consent every time to process the personal data, that's going to be against, the country itself, because
That
we
would be
need to.
harmful.
Yeah, definitely. But go ahead.
No, but I agree, this goes back to one of the comments I made before. Well, what is the purpose of establishing a legal basis? Like, what does it actually do? How does it help privacy? I mean, there's always going to be legitimate interest, of course, is I think regulators would argue is being overused. And so anyway, I'm glad that that's not part of our statutory scheme so far. We do have more data minimization, and I think this is going to be an interesting area because that hasn't necessarily been a concept that has been legally mandated. Now we're seeing it in California, we're seeing it here, we're seeing it in other jurisdictions. I think U.S. companies have gotten into a habit of just collecting data and holding on to it, and having it there and being scared to get rid of it. Seen that change a little bit, but now we're getting to a point where the law is saying you need to actually understand when you don't need the data any longer, or arguably,
but what's the purpose
saying
of
you can only collect what you need as well.
Mm-hmm.
And I don't think Colorado goes quite that far. Some of the regulations, proposed regulations for California, start to go a little further, perhaps. But in the U.S., traditionally, for privacy perspective, we've been a notice jurisdiction. No consent, no legal basis. If you provide notice of the data processing and you're not inaccurate or misrepresenting that activity, then you can do what you do. As long as you say what you do and do what you say, you're fine. But data minimization, arguably, in California's at least proposed rules, says that you really shouldn't be collecting information you don't need at the beginning unless you get consent or get some sort of opt-in or opt-out, whatever. Unclear what the actual mechanism is right yet at this point. I don't think, again, Colorado goes that far, but if that's how things are interpreted in the U.S., that you can collect the business information for the primary purpose, secondary purpose, you need additional affirmation. That's a big change that compared to where we were, because again, all you had to do before was provide that notice. And so I think we're keeping an eye on that issue very carefully.
Okay, very good. Regarding data protection, does it bring any kind of regulation or awareness regarding data protection?
Yeah, it's the kind of the basic, establish appropriate controls. Nothing
new,
blockbuster there. Pretty basic.
Okay. What about the consumer rights?
Yeah, so all the rights you'd be used to. So before, California didn't have a correction right before, they're going to have one now, CPRA. So access, correction, deletion, data portability, opt out of sales, opt out of targeted advertising. So pretty consistent with the approach we're seeing in the other states as well.
Okay, so I feel that transparency and minimization are the biggest issues that companies will have to deal with in Colorado.
I think so.
How do you see it?
There's also a requirement to do data protection impact assessment. For sensitive information. But I think it's fairly narrow, the types of data that entails. And there's a consent requirement.
I mean, it's still a lot of work. I mean, the companies will have to understand what kind of data they collect and use and the purpose to then apply minimization and then apply transparency. And on the top of that, they need to address data impact assessment. So a lot of work, definitely. That
That
That's
didn't exist before.
that didn't exist before.
Unless you were
So,
doing
and
California.
and being in Colorado, how do you see how is the market reacting to that law? I mean, are companies really worried about and doing things to comply with the law, or let's wait a little bit more and see how it goes? I mean,
It's an interesting time. We've been talking about these laws since the beginning of the year. We've done, I think, 3 or 4 presentations on the journey of compliance. In fact, it's called the journey of U.S. compliance. And the first 3 presentations were very widely, a lot of people have joined, but until the most recent one, we didn't see much activity. So now people are seeing the January 1st date and they're starting to move. Others are saying, well, it's not going to be enforced till July. So perhaps we have a little more time. The other factor is sort of the economy, right? That is probably people's priorities have changed in a certain way. And so, focusing on privacy is super important, but some companies are, having to let people go and, are under economic stress. So sometimes that pushes privacy type issues to the back a little bit. But nonetheless, in June and July of this year, we had our busiest Junes and Julys since I've been here. Same with August. So we're seeing a fair amount of activity now in September, especially, where companies are waking up and starting to say, "Hey, we got to take care of this now."
Yeah, we've been working with companies from California, even Virginia and Connecticut, but Colorado is a market that I feel that, as you said, people are getting worried about it now. So we'll see. But anyway, thank you so much, David, for your time. It was great conversation, great stuff. So I do appreciate your time.
Thank you so much. I really enjoyed it. We can do it again someday, and hopefully get to see you, say hello in person soon.
Yeah. Okay, everyone. Thank you very much for being with us. This is another episode of our data privacy podcast. It's going to be uploaded in a couple of hours on Spotify. So be tuned. Thank you. See you then.
Thank you.
Bye-bye.